Good afternoon and welcome. I'm going to say my name is Melida Hudson. I'm the immediate past president of the American Society of International Law, and I thank you for being here with us for this important webinar. I'm going to tell you just a little bit about the American Society of International Law before we get started. ASIL, or the Society as we sometimes refer to it, was formed 120 years ago, and it's the premier international law society in the world, and it's devoted to the development of international law, particularly through convening thought leaders worldwide, both academics and practitioners of various kinds. We hold an annual meeting in Washington, D.C. in the spring, and we actually just had our 120th annual meeting 2 weeks ago, as well as a mid-year meeting, which is held outside of Washington in an effort to sort of bring international law to the rest of the United States. And at that meeting, we also host an important research forum. We also have, for the last 2 years, convened what we have styled ASIL Abroad, which is an effort to sort of recognize and to accommodate the fact that we have 40% of our membership is actually outside of the United States. So last year we were in Singapore. The year before that, we were in Geneva, which was the first time we had been outside the United States officially in about 25 years. And in July, we will be in Buenos Aires. And so if any of you are able to join us, we welcome you. I'm going to start just by introducing our panelists. I'm going to start with Sean Murphy. Professor Sean Murphy is a Manat On Professor of International Law at George Washington University School of Law in Washington, D.C. Professor Murphy began his career as a lawyer in the U.S. Department of State, where he worked on matters relating to armed conflict, claims and investment disputes, and oceans and the environment. As a member of the UN International Law Commission from 2012 to 2022, he served as Special Rapporteur for Crimes Against Humanity, and he now serves as an expert for the United Nations during the negotiation of a Crimes Against Humanity Convention. He is a member of the Board of Editors of the American Journal of International Law and a former president of the American Society of International Law, and a member of l'Institut de Droit International. James Kirk is the legal advisor to the Permanent Mission of Ireland to the United Nations. He represents Ireland in a range of legal fora and processes at the UN, including the Sixth Committee of the UN General Assembly. He participated in the negotiation of the resolution that established the process for the negotiation of a convention on the prevention and punishment of crimes against humanity. He continues to work on that process along with the legal advisor to Ireland's Department of Foreign Affairs and Trade, Declan Smith, who chairs the Preparatory Committee for the UN Conference on Crimes Against Humanity. Ms. Marang Sanyang is the counselor and legal advisor of the Permanent Mission of the Gambia to the United Nations. She represents the Gambia in the third and sixth committees of the United Nations and currently serves as a bureau member of the Preparatory Committee on Crimes Against Humanity, representing the African group. Prior to serving at the Permanent Mission of the Gambia to the UN, Ms. Sanyang served as First Secretary and legal advisor at the Permanent Mission of the Gambia to the African Union and the United Nations Economic Commission for Africa. Ana Paula Lavalle is the third committee coordinator and legal advisor at the Permanent Mission of Mexico to the United Nations. She co-facilitated, together with the Gambia, Resolution 79/122 that decided to convene the United Nations Conference of Plenipotentiaries on Prevention and Punishment of Crimes Against Humanity. Currently, she serves as a bureau member of the Preparatory Committee on Crimes Against Humanity, representing the group of Latin American and the Caribbean. Ambassador Andrei Melnik is one of Ukraine's most distinguished diplomats with 3 decades of experience in diplomatic service. Over the course of his career, he has held several senior government positions, He served twice as a member of the Ukrainian government, first in 2014 to 2015 as Deputy Minister of the Cabinet of Ministers, where he was responsible for international relations and European integration, and later in 2022 to 2023 as Deputy Minister of Foreign Affairs of Ukraine, responsible for International Law Directorate. Ambassador Melnyk also brings extensive ambassadorial experience. He served as Ukraine's ambassador to Germany from 2014 to 2022, and subsequently as ambassador to Brazil from 2023 to 2025. Throughout his diplomatic career, he has been a member of numerous governmental delegations and has contributed significantly to the field of public international law as the author of a wide range of books and scholarly articles. Since January 2026, Ambassador Melnyk has served as a member of the Bureau of the Preparatory Committee for the UN Conference of Plenipotentiaries for the Prevention and Punishment of Crimes Against Humanity, representing the Eastern European Group. Last but not least, Mr. Theodolos Pitakis serves as legal advisor at the Permanent Mission of Cyprus to the United Nations. In this capacity, he represents Cyprus in the Sixth Committee, Legal, of the General Assembly and in other fora of the United Nations. He currently serves as a member also of the Bureau of the Preparatory Committee, representing the Asia-Pacific Group. He also acts as facilitator for the annual Sixth Committee resolution on relations between the United Nations and the host country. Previously, he served as Consul of the Republic of Cyprus in Beijing, China, and as legal advisor at the Permanent Representation of Cyprus to the Council of Europe in Strasbourg. He also served as a liaison officer of the Ministry of Foreign Affairs of Cyprus with the United Nations Peacekeeping Force in Cyprus. With that, I'm going to begin by asking Sean to tell us a little bit about his work and the work of the ILC in developing the draft articles and how he views or what he views as the key provisions. Sean.
Well, thank you very much, Melda, for the kind introduction. It's really a pleasure to be here. Thanks to the Robert H. Jackson Center for the invitation and the American Society of International Law. Since this symposium is a series of reflections on 80 years since the Nuremberg Charter and the Nuremberg trials, I think maybe it's worth connecting the current negotiations back to that point in time. And so to start, I'll note that one of the unique things about the Nuremberg Charter and the Nuremberg trials is that for the first time, there was a recognition that the way a government treats its own people is a matter of international concern. It was already understood at that time that there could be war crimes concerning an international armed conflict, that there could be issues of use of force and aggression. It was less well understood that the conduct of a government against its own people could constitute something that might be a crime against humanity. So this is reflected in the Nuremberg Charter and is prosecuted at the Nuremberg trials. The other important thing, of course, is that this was not just the responsibility of the state in this kind of conduct, but individual criminal responsibility of senior leaders to the extent that they committed such crimes. So this was a watershed moment. And in the aftermath of it, in the post-World War II period, there were various steps being taken to address things coming out of the Nuremberg Tribunal. Of course, the UN Charter is adopted, and it's speaking to the use of force and aggression by states against each other. 1948, Convention Against Genocide, dealing with that particular crime and speaking as well in Article 6 to the possibility of prosecutions in national courts. 1949, the Geneva Conventions addressing war crimes, again, provisions on prosecutions in national courts, but no convention emerges dealing with crimes against humanity. as it relates to what might happen in national jurisdictions and so on. Um, at the same time, while these Nuremberg tribunals are going on, you do have, of course, the General Assembly at the UN being set up, and Article 13 of the UN Charter says one of the functions of the General Assembly is to encourage the codification and progressive development of international law. So you do have in 1946 the General Assembly setting up, establishing the UN International Law Commission. The ILC is going to be a body of experts brought from around the world, not representing governments, but operating in an expert capacity for the purpose of looking at different areas of international law and codifying or progressively developing the law in that area. One of the very first projects of the ILC are what become the 1950 Nuremberg Principles. So it's a distillation of the rules from the Nuremberg Charter, from the Nuremberg trials, all sort of reduced down to 7 principles plus commentary, which, among other things, lays out crimes against humanity as one of the most grave crimes of international law. At the time, this was thought as possibly the prelude to the establishment of an international criminal court. And in that spirit, the ILC moves forward in 1954, adopting a draft code of offenses against peace and security of mankind, also addressing crimes against humanity. But it's too difficult to develop an international court. It takes decades until you get to the 1990s where it becomes a real possibility. And so at that time, the ILC in 1994 does a draft statute for an international criminal court that eventually becomes the Rome Statute. It does include crimes against humanity. Also in 1996, the ILC produces a draft code of offenses against peace and security. Again, crimes against humanity is in that, and it also influences what eventually becomes the Rome Statute. Um, but what about prosecutions in national law? It seems to have sort of dropped off the radar screen in those decades. There are national statutes being adopted by states. There are some national prosecutions going forward, famously the Eichmann trial, the Barbie and Touvier trials in France, the Menton trial. So things are happening, but there's no treaty regulating this adoption of national laws to address crimes against humanity, even though in this same time period, you have treaties like the Convention Against Torture addressing that crime and talking about how it needs to be regulated in national systems. Convention on Trafficking Against Persons, Convention on Enforced Disappearance. There are a number of treaties addressing different types of crimes in the context of national laws, but not on crimes against humanity. So this leads, certainly by the 1990s, to calls within the academic community, NGO community, even some states. It's time to do a global treaty on crimes against humanity that will build up national laws, national jurisdiction. So the ILC decides it's going to embark on a project that will draft articles that could serve as the basis for such a convention. It adopts this topic in 2014 as part of its work program, and it appointed me special rapporteur. So in 2015, I do my first report on crimes against humanity. That report, in part, connects the Nuremberg legacy to the need for this new initiative. Also begins the process of proposing articles for a draft convention. A second report in 2015, a third report in 2017. That results in a complete set of draft articles adopted on first reading by the ILC and sent to New York for an initial scrutiny. And over the period of about 2 years, we get comments from governments, both orally and in writing. We get comments from international organizations, from human rights committees, mandate holders, and indeed more than 700 NGOs and individuals provided comments on our first draft, which then leads to the second draft concluded in 2019. It's a preamble, 15 draft articles, and an annex on mutual legal assistance that reflects a lot of the comments that we received from different constituencies. And so we send that forward in 2019 to the UN General Assembly with a recommendation that the General Assembly convene a conference of states to do a diplomatic negotiation that would lead to the adoption of a convention. So just briefly, in conclusion, what are the key provisions? You do have in Article 2, Draft Article 2, a definition of crimes against humanity, largely drawn from the definition that appears in the Rome Statute. Article 4, you have an obligation of prevention. This is a convention that would be on both prevention and punishment. Article 6, a detailed article about how states have to criminalize this conduct in their national law. Article 7, they have to establish jurisdiction over alleged offenders. It could be their nationals, it could be persons who turn up in their territory. Articles 8 to 10 talk about investigation of possible crimes against humanity, apprehension of persons who are in your territory that you think committed such crimes, and then importantly, an obligation if the person's in your territory to prosecute them, submit the matter to prosecution, or possibly extradite to another state that's willing to do so. There's a draft Article 11 about fair treatment of alleged offenders, draft Article 12 about the rights of victims, witnesses, and others. Articles 13 and 14 are on interstate cooperation, particularly as it relates to extradition and mutual legal assistance. And then finally, Article 15 on dispute settlement, including before the International Court of Justice. So I think I should leave it at that, only to finish by saying I was delighted in December 2024 that the General Assembly did decide to move forward with the diplomatic negotiations, and that I'm very much looking forward to being an expert for those negotiations as they move forward.
Thank you very much, Sean, for that very comprehensive overview. I think especially to the extent there may be people who are not familiar with the day-to-day on this, I think it's really quite useful. And of course, there's some preparatory meetings that began in January. So I think with that, I'll ask Mr. Kirk to give us an overview of the intergovernmental process that is being undertaken.
Thank you, Melida, and thanks again to the American Society of International Law for organizing today's webinar and for inviting me to speak. As Melida said earlier, I'm the legal advisor at the Permanent Mission of Ireland to the UN, and I'm working on the Crimes Against Humanity process, along with the legal advisor to the Irish Foreign Ministry, Declan Smith, my boss, who chairs the Preparatory Committee for the UN Conference on Crimes Against Humanity. So today I'm going to build on what Sean has explained about the International Law Commission's work on the draft articles by providing an overview of the intergovernmental process that followed the completion of the ILC's work and will continue until at least 2029. As Sean explained, in 2019, the ILC adopted the final text of the draft articles and recommended the elaboration of a convention on the basis of them. The draft articles and the ILC's recommendation were then considered and debated for several years within the Sixth Committee of the UN General Assembly, which is the Assembly's legal committee. The Sixth Committee convenes for around 2 months each autumn, and it's the primary forum in which states consider the development of international law at the UN. When it first considered the final text of the draft articles during its 2019 session, the Sixth Committee took note of the ILC's recommendation to elaborate a convention and decided to examine the matter further the following year. It then continued examining the matter annually. in 2022, the Sixth Committee decided that before taking a final decision on the ILC's recommendation, it would hold 2 resumed sessions in addition to its annual autumn sessions in April 2023 and April 2024 in order to discuss the substance of the articles in more detail. This decision was taken because although a large number of states wished to proceed directly to the negotiation of a convention, a significant minority of other states took the view that it was necessary to discuss the articles in greater substantive detail than had so far been possible during the usual autumn Sixth Committee sessions, which cover a wide range of legal matters within a relatively short period. The resumed sessions in April 2023 and April 2024 each took place over the course of a week and allowed for detailed discussion of each of the draft articles, which were divided into clusters for the purposes of the discussion. Following these 2 resumed sessions, the Sixth Committee finally took a decision on the ILC's recommendation during its regular session in autumn 2024. By this time, a large number of states were supportive of elaborating a convention, but a smaller number of states still remained opposed to or skeptical about doing so. Early in the Sixth Committee session that year, a large group of supportive states, led by Mexico and the Gambia, proposed a draft resolution that would establish a process leading ultimately to the elaboration of a convention. This draft resolution was then negotiated intensively throughout the session. Now, it's customary in the Sixth Committee to seek to reach decisions by consensus rather than through voting, so huge efforts were made to find compromises on various elements of the draft that would make it acceptable to opposing and skeptical states. Following a number of compromises, including in relation to the timeline for the negotiation of a convention, the resolution was adopted without a vote. The resolution establishing the treaty negotiation process, Resolution 79122, decided to convene a UN Conference of Plenipotentiaries on Prevention and Punishment of Crimes Against Humanity to meet at UN headquarters in New York for 3 weeks in 2028 and 3 weeks in 2029 in order to elaborate and conclude a legally binding instrument on prevention and punishment of crimes against humanity. The resolution also allows for the possibility of holding an additional session, if necessary, bearing in mind the aim of developing an instrument enjoying the broadest possible support. Resolution 79122 also decided to convene a preparatory committee for the conference to meet in January 2026 and again in 2027. The preparatory work to be carried out before the conference in 2028 includes preparation of the text that will serve as the basis for negotiations during the conference, as well as discussion of the organization and methods of work of the conference, including its rules of procedure. The preparatory committee met for 2 weeks in January of this year and conducted a detailed working group discussion of the draft articles in order to enable states to prepare formal proposals for amendments to the draft articles. These proposals will be included in a compiled text to serve as the basis for negotiations, consisting of both the draft articles and a compilation of amendment proposals by governments. The working group discussion in January was a very rich substantive discussion, which was facilitated by Sean's presence throughout the 2 weeks. It provided an opportunity for states to discuss the draft articles with each other and to ask Sean questions about specific aspects of the ILC's work on the articles. In addition to substantively discussing the draft articles during its January meeting, states also considered one aspect of the organization and methods of work of the conference, namely the participation of stakeholders other than states, including non-governmental organizations. Resolution 79122 had already decided that attendance at the conference would be open to relevant NGOs that are in consultative status with the UN Economic and Social Council, but it left open the question of which other stakeholders could participate in the conference. Following informal consultations on the matter throughout the 2-week meeting, which were led by the South African delegate, the Preparatory Committee decided to invite representatives of relevant NGOs, other than those in consultative status with the Economic and Social Council, civil society organizations, academic institutions, and the private sector to submit requests to participate in the conference. A list of these requests will ultimately be brought to the attention of the General Assembly for a decision on participation in the conference. Following the first meeting of the Preparatory Committee in January, states had until 30th of April this year to submit formal proposals for amendments to the draft articles. As I said, these proposals will be included in the compiled text that will serve as the basis for negotiations in 2028 and 2029. We are now just 1 week past that deadline, so it will be interesting to review the proposals when they become available on the website that the UN Secretariat has established specifically for the Crimes Against Humanity process. The Secretary General will ultimately submit the proposed compiled text to the Preparatory Committee in advance of its second session. The Preparatory Committee will meet again at that second session in April next year to complete the preparatory work for the conference. It will by then have received from the Secretary General the proposed compiled text and will therefore be in a position to transmit the text to the conference. The Preparatory Committee will also complete its discussion of the organization and methods of work of the conference with a view to making recommendations in this respect to the conference. A key element of this discussion will be consideration of the rules of procedure that will govern the conference. Following the conclusion of the work of the Preparatory Committee in April next year, states will then have the remainder of the year to prepare for the first meeting of the conference in early 2028. I'll leave it there for now. Thanks very much, Melida, and I look forward to hearing from my friends and colleagues on the panel.
Thanks so very much, James. That's an excellent overview of where we're going and where we've come in this past couple of years, several years. I would like to ask then if the various representatives, representatives of the various regional groups would like to speak. Ana Paula, I see you've put your camera on, so perhaps you'd like to make some comments either on Sean's historical overview or James's sort of current and future overview, or whatever you would like to mention about the process. Please go ahead.
First, I would like to thank the American Society of International Law for the invitation for an organization of this timely webinar. On the process, I think, as explained by Professor Murphy, the ongoing process towards the beginning of negotiations, it's an historic opportunity to bridge a legal gap that has very practical consequences, and this convention will have an effect on how states deal with the prevention, domestic criminalization, interstate cooperation, extradition, mutual legal assistance, and the accountability for some of the gravest crimes affecting humanity as a whole. So this wasn't an easy process. Getting towards consensus, as James already explained, there is a tradition of consensus in the Sixth Committee, and getting the different states together, bringing them to have this mandate of beginning negotiations was challenging, but the commitment is there now, and we start this process with good news that there is consensus on starting negotiations and starting this process, and that is our starting point now. So bringing the perspective from the group of Latin America and the Caribbean, I would just like to clarify that there is no formal substantive coordination within the group. So the representation I hold in the Bureau is for informative procedural questions, but I do have some, from some perspectives from the regional group, from the previous resume sessions that James mentioned, the commentaries that were sent, and the preparatory committee that was also mentioned that took place in January this year. So the group of Latin American states is one of the strongest and most constructive regional supporters of this process towards having a convention. Across the region, there is broad support for advancing a legally binding instrument based on the ILC draft articles. But many countries in the region have expressed support for moving negotiations forward. Also, naturally, there are different emphasis and priorities. But one of the most notable characteristic of the GRULAC, or GRULAC's engagement in the process, has been the combination of strong support for accountability with equal support for multilateralism, sovereignty, and the purposes and principles of the United Nations Charter. So this balance is important also because our region's positions are deeply informed by a historical experience. Latin America in the past has encountered dictatorships, enforced disappearances, torture, political prosecution, transitional justice processes that have shaped the region's priorities and that interact and have relevance in these negotiations. So perhaps one of the clearest examples of regional convergence concerns the normative status of crimes against humanity. So, for example, several Latin American delegations have supported explicitly recognizing the prohibition of crimes against humanity as a jus cogens norms. So recognizing crimes against humanity as jus cogens reinforces the universal nature of this prohibition, and it strengthens the obligations to prevent and punish these crimes, helps consolidate the understanding that these crimes concern the international community as a whole, and it also has implications in other issues such as amnesties, immunities, or status of limitation, for example. At the same time, some GRULAC delegations also have emphasized the importance of preserving the integrity of multilateral order. So, for example, by stressing that the convention should not become a pretext for intervention or for actions inconsistent with the prohibition on the use of force. Mexico, for example, has advocated for stronger references not only to the principles of the Charter, which are references in the preamble of the draft article, but also to include the purposes of the UN, which refer explicitly to including maintaining international peace and security or the protection of human rights. It's also a priority of my delegation to include a human rights perspective throughout the future convention. Another important area that has been raised is, and I think Professor Murphy mentioned on Article 2, the definitions. So most Latin American states supported using definitions on Article 7 of the Rome Statute as a baseline definition for crimes against humanity. However, many states in the region also emphasize that the Rome Statute should function as the floor and not the ceiling. So, in other words, it should provide the foundation for legal harmonization, and we think it's important for consistency and coherence in the legal system. but still allowing space for the progressive development of international law and reflecting other conducts that have been already being prosecuted in tribunals as other crimes. Also, several GRULAC delegations have demonstrated openness to discuss incorporating conducts that may not be fully reflected in existing formulations of the articles, including issues such as forced marriage, gender apartheid, slave trade, or other forms of prosecution. So we think, or the group in general remains responsive to contemporary realities, but also given our civil law in general legal tradition, it's important also to maintain legal clarity and certainty. Another defining characteristic of the group's perspective has been a strong victim-centered approach, which is also related to this human rights perspective that I mentioned earlier. So this is perhaps also unsurprising considering the region's extensive experience with transitional justice mechanisms, truth commissions, reparation programs, and the jurisprudence of the Inter-American Court of Human Rights. So the way also we see this future convention is not only a criminal law convention, but it's a criminal law and human rights convention. Many states have also emphasized that victims and survivors must remain at the heart of the convention, ensuring the participation rights, access to justice, the right to truth, and comprehensive reparations. So this convention should not only be about, it is about accountability, but also about restoring dignity, rebuilding trust, and repairing the social fabric that damaged by these atrocity crimes. Several Latin American states have also referenced to the provision on non-refoulement. This is also linked to the region's increasing engagement with broader human rights and humanitarian protection frameworks, particularly in relation to migration or forced displacement. Also, the region has demonstrated strong support for accountability measures at the domestic level, including by supporting explicit prohibition on amnesties or status of limitation for crimes against humanity. These positions are also connected to the region's historical struggles, and our Inter-American Court of Human Rights jurisprudence. Mexico proposed also exploring the creation of a permanent non-adversarial monitoring body. This is the model that we presented in the commentaries is inspired by, in the proposal, is inspired by the subcommittee on the prevention of torture. So the idea that we presented is to establish a mechanism focused not only on accountability, but also on prevention and technical assistance, capacity building, institutional strengthening, and cooperation among states. This proposal is also a reflection of a broader regional understanding that prevention and punishment are complementary rather than separate objectives. And of course, not all positions within the region are identical. There are also a few dissenting voices that question whether negotiations are premature. James already explained about the concessions and the negotiations and these intermediate steps in the process that were necessary to tackle that perception. And some of them also have expressed skepticism regarding the convention's relationship with the Rome Statute system. That's also like something that few delegations have expressed in other regions. But despite some differences, the overall picture, I think it's clear that as negotiations continue, Latin America will likely continue playing an important role in bridging as bridge building and the work. We will work hard in helping shape the convention that is not only legally robust, but politically viable and capable of achieving broad international support. So that's what I have to say about our perspective in the region and the process.
Thank you. I think that was very, very comprehensive, and I think there are always going to be challenges, obviously, even within regional groups, and that's I think it's great that so far the process has allowed for trying to accommodate the dissonant voices, but I think I appreciate the work that Mexico is doing to ensure that this will be successful and that all voices are heard in essence. I do want to note that I see from the chat that we have people not only from all over the United States, but also, as far as I can see, from Egypt and Hungary and Canada. So clearly there is really widespread interest in the work that you all are doing. With that, I will ask Ambassador Melnick if he has comments that he would like to make.
Thank you, dear Melinda. Thank you, Professor Murphy, dear Sean, distinguished colleagues. So good to see you all again after a certain pause. Just a few reflections on the topic. Thank you for this invitation and this timely meeting that we can really now have with some distance assess what happened. Ukraine, together with the overwhelming majority of the states belonging to the so-called Eastern European group, genuinely welcomes this long-awaited launch of negotiations on the Convention on Crimes Against Humanity. After many years that we just heard what Professor Murphy presented, the history at the beginning and the origins of all the discussions. After many discussions and advocacy, this process has finally begun. And this is, without any exaggeration, excellent news for the international community, but also for the progressive development of international law. At the same time, the very first session of the Preparatory Committee in January clearly demonstrated that this journey will not be an easy one. As many of us expected, the same forces that for many years attempted to slow down or even obstruct this initiative manifested themselves from the very opening moments of the committee's work that started in January. And one hardly needs to look further than the ridiculous episode where certain delegations led by the Russian Federation, not surprisingly, effectively stalled the work of the Preparatory Committee for many days by attempting to slow down the process and even to prevent the election of the Bureau. And many here in our friendly circle will recall that a vote had to be forced after alternative candidacies were put forward. And for us, for me personally, this episode served as an early signal, perhaps even symbolic warning that the process of negotiating a convention on crimes against humanity will be complex, will be politically sensitive, and far from straightforward. And although the Russian Federation then ultimately failed to be elected to the Bureau, and that was something that they probably did not expect to happen, with both Slovenia and Ukraine, the two countries that gained the majority of votes and which are firmly committed to a genuinely ambitious text of the convention, this outcome nonetheless carries an important lesson and for us all. Still, the Russian candidate received more than 70 votes in that process, and that also shall serve maybe as a sobering signal for us all, because it demonstrates that a significant number of states still continue to sympathize, at least in part, with approaches that risk torpedoing the negotiations, slowing this momentum that we just gained, or even diluting the very purpose of this convention. And these realities remind us that the negotiation of a convention on crimes against humanity will not only be a purely legal exercise, but also a litmus test of our political commitment to continue this process. During the meetings of the committee, we also repeatedly heard a consistent line which was advanced by a number of states, not only by Russia this time, which continue to insist that international law does not require any further codification with regard to crimes against humanity, and that there is actually no need for such a convention. And at the same time, while these delegations formally express openness and readiness to engage constructively in the process, we still have to interpret these signals as a certain indication that further work on the text of the convention will be very, very challenging. At least as far as our Eastern European group is concerned, although formally and regrettably due to the division that emerged following Russia's full-scale aggression, the situation remains complicated. In practice, the overwhelming majority of states within our group are ready to work towards achieving the most ambitious text around which, as we hope, the vast majority of UN member states will ultimately unite. Dear colleagues, I would now like to outline just three basic positions which reflect the stance of Ukraine, but which, as I have come to understand following discussions within our group, also can be seen as reflecting a broader common approach. First and foremost, we are convinced that the text of the future convention will largely be based on the draft articles prepared by the distinguished Professor Sean Murphy and adopted by the Commission. We have this understanding, and this is also something that we clearly observed during the first session of the committee, and in my view, it does reflect the position of the overwhelming majority of states. The second point is that we could note a certain divide. It could be felt during the discussions between the positions of states that are parties to the Rome Statute and those that have not joined it. We could observe a very clear position expressed by a number of member states which, in effect, question and seek to dilute the experience accumulated over nearly 30 years stemming from the practice of International Criminal Court, and this will likely remain a significant challenge for the Preparatory Committee and then for the conference for the member states going forward. And finally, the last element that I would like to mention, Ukraine, which is a victim of Russia's full-scale military invasion and which regrettably faces daily numerous war crimes as well as crimes against humanity as a result of that barbaric war of aggression, which is aimed at the destruction of the Ukrainian statehood and the Ukrainian nation. So therefore, we as a delegation, together with our allies and member states, not just from the Eastern European group, but also from other groups, we will actively promote during the forthcoming negotiation process a number of elements that could further improve and complement the draft articles prepared by the ILC. One of the main concerns is the protection of children. Ukraine co-sponsored several initiatives aimed at strengthening the draft articles in relation to crimes committed against children. And these discussions, they reflect a broader reality, because contemporary conflicts increasingly expose children not only to physical violence, but also to unlawful transfer, abduction, militarization, exploitation, and systematic attacks on their identity. And at the same time, we are, of course, realists, and we have no illusions, because that will be a very difficult process that lies ahead of us. But we hope that all those proposals that have been now submitted by the end of April, also by our delegation, that they can also create a momentum and really move maybe a little bit beyond the scope of the draft article that we have. And we will be striving to improve this text and achieve a genuine progressive development of international law. But still, our main guiding consideration will remain ensuring that the future convention attains the broadest possible support and is ultimately adopted in accordance with the timeline that was established by member states. To wrap up my comments, I would like just to remind our participants today that for Ukraine, this codification process has a very special historic significance. The very intellectual foundations of modern international criminal law are inseparably linked to Ukraine, and in particular to my native city of Lviv, my alma mater, the Lviv National University. It was there that the legal visionaries such as Herr Schlauterpacht, who developed the very concept of crimes against humanity, or Raphael Lemkin, who was the architect of the Genocide Convention, and of course Louis Son, who studied, lived, and shaped those ideas that transformed international law forever. Their groundbreaking work laid the legal and moral foundations of the post-war international order and redefined humanity's understanding of individual criminal responsibility. So therefore, we hope as Ukrainians that this codification process could be concluded in the city of Lviv, which is the birthplace of the very notion of the crimes against humanity. So I thank you again for your invitation, and I wish you a fruitful discussion today. Thank you so much.
Thank you so much, Ambassador. That was an excellent sort of overview of where you stand, and introducing an important element that I think important probably for many, not only Ukraine, on the issue of children. I know we have a question in the chat box or in the question box, but I think before moving to that, I think we should have all the perspectives. So I would ask if either Ms. Sanyang or Mr. Pataki is ready to give their regional perspectives.
Okay, well, thank you, Marang. Thank you, dear Melinda. Good afternoon. I would also like to thank the American Society of International Law for organizing this very important webinar. It's also my pleasure and honor to be among the members of this panel. My name is Theo Bitakis. I'm the legal advisor here at the Permanent Mission of Cyprus at the United Nations. I'm one of the two representatives of the Asia Pacific group in the Bureau of the Preparatory Committee for Crimes Against Humanity. I'm also serving as the rapporteur of the Preparatory Committee. I would also like to add from my side that this is a historical step, the process that we have all embarked for several years now, to bridge a gap, a long existing gap in the area of international law and international justice, to fight impunity and enhance accountability in the most serious international crimes. Now, if you allow me some information on the perspective of the Asia Pacific group, this is a group with quite significant number of members. There are different views and approaches when it comes to the draft articles and whether to proceed to a convention on the prevention and punishment of crimes against humanity. In general, I would identify three subgroups with different views within the Asia Pacific group. First group, of course, Cyprus, my own country, together with countries like Timor-Leste, Republic of Korea, Japan, Vanuatu, the State of Palestine, Lebanon, and Jordan. We fully support the process and the elaboration of a convention on the prevention and punishment of crimes against humanity. We firmly believe that the draft articles as prepared by the International Law Commission provide a solid basis, a good foundation for the convention. A second subgroup of states is the one with Kingdom of Saudi Arabia, Iran, United Arab Emirates, China, India, Democratic People's Republic of Korea, Burundi, Pakistan. These states are skeptical and have strong reservations regarding the convention. They believe that a convention is still premature. They're against a rushed process that could lead to legal fragmentation and selective inclusion of doctrines that extend beyond customary international law. They support a consensus-based process. Iran emphasizes on the need for universality. India is of the view that more thorough discussion is needed. They consider that a convention of this matter has a risk of duplication with existing instruments, and that a possible instrument must respect state sovereignty and primacy of national jurisdiction. Pakistan has concerns on draft Articles 7, 9, and 10. Then a third group of states with a similar approach is the one with, I would say, Philippines, Singapore, Indonesia, and Iraq. This subgroup of states is open to discussion. Singapore and Indonesia share the view that the convention must respect the Charter and especially Article 2. Focus should be on domestic prosecution, and any other form must be considered complementary. Iraq is quite open. Draft articles provide a good basis. Nonetheless, it must not be the only basis for discussions. They focus on the need for respect of national sovereignty as well and national legal systems. Philippines are also quite open. They're in favor of an effective and implementable instrument, effective prevention through national measures, reparation, restitution, and rehabilitation of victims, and open to include in the definition other terms like gender apartheid, slavery, children, most affected. States from subgroups 2 and 3 underscore the need for full respect of national sovereignty, non-intervention, primacy of national jurisdiction, and complementarity. And of course, due to the diverging views within the Asia Pacific group, there is no official coordination as a group, but we are all working, having a dialogue on how to proceed constructively. Now, if you allow me some specific information on some key provisions from different clusters. On cluster 1, on the preamble, a group of states like Saudi Arabia, India, Iran, China, they support explicit listing of sovereign-related principles. On preamble of paragraph 4 and the prohibition of crimes against humanity as peremptory norm as jus cogens. This is also one of the most divisive topics. Cyprus is among those states that consider the prohibition of crimes against humanity as widely recognized as jus cogens, that an explicit reference should be made to this convention. Other states like Saudi Arabia, India, Iran, Singapore, and China object to this reference. They claim that there is a lack of consensus on the definition of crimes against humanity and hence cannot be considered as jus cogens. On preambular paragraph 7 and the reference to Article 7 of the Rome Statute, Cyprus, Timor-Leste, the Philippines are among the states that support this reference. The definition contained in the Rome Statute is one of the most developed and used by the international community, and that reference would serve as descriptive purpose and would in no way be binding for non-state parties to the Rome Statute. Other states like India, Singapore, China consider that including such a reference would imply an endorsement on the Rome Statute and its obligations, and it would be more appropriate to mention the Nuremberg or the United Nations Charter. On cluster 2 and the definition, a group of states, including my country, Timor-Leste, Republic of Korea, and Japan, Timor-Leste, are among the members of the Asia-Pacific group that consider that the definition of crimes against humanity should be based on the Rome Statute. We believe that it reflects the most developed and widely applied definition in the international law and provides legal certainty without binding non-state parties to the ICC. Other states like China, Iran, India, Singapore, Saudi Arabia, and others are opposing that Article 7 does not reflect settled customary international law. It lacks universal acceptance and risks importing ICC interpretations into a new treaty framework. Also, on draft Article 6, Cyprus and others support the application to criminalize crimes against humanity under international law as an essential element. Other states like China, Iran, Indonesia are of the view that this provision risks over-prescription and should allow flexibility to reflect different legal systems. On draft Article 7, also my country is among states supporting broad jurisdictional basis to prevent safe havens. On the other hand, China, Iran, India oppose universal jurisdiction, providing the argument that these risks of abuse and conflicts of jurisdiction. These are only some examples of the views on key provisions of draft articles by different members of the Asia-Pacific group. Cyprus will continue to work constructively with all members of the Asia-Pacific groups and also all other states of the United Nations to advance discussions. Our aim is to have all different voices heard. Our aim is to advance discussions and elaborate a convention on the prevention and punishment of crimes against humanity. We want a legally robust international instrument, as my colleagues that have already taken the floor said, with as broad international support as possible. And in this framework, Cyprus, together with other states, will continue discussions with all states, and especially with states that have reservations, that are skeptical, in order to identify ways to move forward with the elaboration of the convention. And before concluding, I would like to inform that Cyprus forms a part of a cross-regional group together with states like Andorra, Ukraine, Armenia, Timor-Leste that have submitted amendments aiming to enhance the children's protection in the convention. Thank you very much.
Excellent. Thank you, Theo. I think with that, we will move, last but certainly not least, to Maran Sanyang to give us the African perspective.
Thank you very much. Thank you, Melinda, and of course, the American Society of International Law for the opportunity to speak and to share our experiences in this important process as we proceed to preparing a standalone convention on the prevention and punishment of crimes against humanity, of course, following the adoption of the historical Resolution 79122 in December 2024. I also wish to thank Professor San Murphy for his constructive role in this process. I'm also very happy to see my colleagues here as we all share our experiences. Of course, I'll start with the Gambia. In the view of the Gambia, of course, the ILC draft articles provide a sound and balanced basis, of course, for further negotiation, and we have reflected this during the Preparatory Committee. We believe that they reflect existing international law, of course, fill a recognized normative gap, and offer a framework capable of broad acceptance. For my presentation this afternoon, it will be based on, of course, the commentaries that have been made and the submissions that were made by the states, the African states, of course, and as well as the African group. Just like Gulag, of course, with the African group, our positions are not all the same. But there are key issues that we have found to be very important in this process. First of all, the African group have always echoed the fact that the process has to be transparent and inclusive as possible, recognizing the fundamental importance of it, as well as what is reflected in Resolution 79/122, in stressing that the conference should be undertaken in an open and transparent manner, with a view to promoting, of course, universal adherence. Equally important is the necessity to ensure that it enjoys the widest possible support and effective participation of all states. The first aspect of the African view, in terms of those aspects that we feel that it can enjoy a wide support within our group, the issues concerning historical crimes. So several African states have, during the debate of the ILC 2019, on the ILC 2019 draft articles, proposed or supported inclusion of slave trade or slave trading as crimes against humanity in the future convention. In the current context, the draft prohibits or did not indicate enslavement, but does not provide a provision for slave trading. The prohibition of slavery is not just a jus cogens norm, meaning it is a norm of general international law from which no derogation is permitted, but it is also prohibited under established international instruments for the African group. And the reason why the African group decided to support this aspect of slavery and slave trading is also because it emanates from the African common position. The African group had welcomed a historical decision which was made in February 2025 at the level of the heads of states, in which a resolution was passed qualifying slavery, deportation, and colonization as crimes against humanity and genocide against African people. This important decision recognizes the violence and denial of human dignity that marked these periods and aims to establish a new legal framework for recognition and reparatory justice. So a lot of African states during the Preparatory Committee and during the resumed session had indeed indicated that there is a need for the draft articles to include slavery and slave trading as crimes against humanity. That is a position that the African group has. Of course, on the issue of capacity building and mutual legal assistance, given the fact that the treaty is dealing with horizontal obligations of states, and it is within the remit of states to punish these crimes, the African group believe that there is a need to have a provision dealing with capacity building and the strengthening of cooperation. Of course, when it comes to the divergences, one of the divergences is on the actual definition of crimes against humanity, as stipulated in Article 2 of the draft articles, with regards to the use of the Rome Statute in the text. There are some African states who felt that the Rome Statute does not enjoy a universal status, and therefore the definition of crimes against humanity should not be derived from the Rome Statute. Nonetheless, there are other African states, such as the Gambia, who of course support the inclusion of the Rome Statute, considering that Africa has the highest number, of course, of representation of state parties to the Rome Statute. For the Gambia, as a signatory to the Rome Statute, as I highlighted before, using Article 7 should be a foundational reference, particularly given that the provisions on crimes against humanity within the Rome Statute resulted from thorough multilateral intergovernmental negotiations preceding and during the Rome Conference, offering a comprehensive and widely recognized definition which aligns with customary international law. So there is a little bit of divergence in terms of perspectives with regards to the actual definition of crimes against humanity in the Rome Statute, with regards to the African perspectives, with some states indicating that it should be a starting point, as highlighted by my colleague Anna from Gulag, whilst others are of the opinion that since they are not parties to the Rome Statute the definition of crimes against humanity that should not be taken from the Rome Statute to begin with in this process. So that divergence is there. Again, other African states also highlighted the issue of sovereignty and territorial integrity. And I had my colleague Theo also mention that from his region. So some African groups also alluded that the fundamental legal principles of territorial integrity, sovereign equality of states, and non-interference in the internal affairs of states enshrined in the UN Charter should also be explicitly mentioned in the draft articles, given the horizontal nature of the articles. International cooperation as well, they believe that international cooperation should be strengthened. Countries like Gambia believe that that should particularly happen in the context of proceeds of crimes that are gotten from crimes against humanity, that there has to be some form of mechanisms or some form of strengthening of cooperation dealing with crimes that are gotten, proceeds of crimes with regards to crimes against humanity. The African group also believe in the aspect of environmental justice as well. There were states that that mentioned the issue of environmental justice should be included as crimes, one of the offenses for crimes against humanity, as well as the issue of recruitment of children as well. I know that Gambia has joined Andorra and other countries in supporting the fact that there has to be a provision that caters for the needs of children. And of course, that also includes the judicial proceedings when it involves a child, that the best interest of the child should always be considered when dealing with offenses of this nature. Again, complementarity also was highlighted within the applicable rules. Of course, there are African countries that also spoke about the issue of immunities, that should be considered within the context of the draft articles. And there are other African countries, such as the Gambia, that believe that is of the position that there should not be any immunity when it comes to crimes against humanity. Again, also on the issue of reservations as well, there are African states that believe that there has to be a provision that offers reservation, that states have the right to enter reservations given the Vienna Convention on the Law of Treaties. And the Gambia, of course, and other countries such as Belgium and others supported proposals to indicate that given the gravity of the offense that we are talking about, it is important, or it will be important, that there should not be no reservation when it comes to issues on crimes against humanity. So definitely divergent views, but of course the African group still committed to the process, still committed to ensuring that we have our voices heard, particularly on historical experiences of the issue of slavery and slave trading. So that's where I would stop for now. And if I could have any further question, I'll be glad to answer. Thank you.
Thank you very much. And I think as we see, yes, we see some sort of crossovers in terms of areas where the different regional groups would like to see cooperation or collaboration in terms of going perhaps a little bit further than the draft articles even on some specific types of crimes that could be defined as crimes against humanity, such as with respect to children or forced marriage, gender apartheid, slave trade, as you've mentioned. And I think this will all make for just a fantastic negotiations as we go ahead. But certainly a lot of work for all of you to try to bring this all together. Recognizing that we have a question in the chat, which I will read, and not surprising to some extent, some of you have touched upon this issue a little bit. Well, the issue of the ICC, I guess, and perhaps not directly, but the question is, could you please shed light on the initiatives or actions taken by the UN Security Council and significant stakeholders to challenge the sanctions imposed on the ICC officials? The sanctions regime. Sorry, the question was taken down, so I don't see the rest of it, but we'll stick with the first part of the question, I guess. My guess is the rest of the question was going to go to perhaps the ineffectiveness or the difficulties of dealing with the current sanction regime. I don't know if anyone wants to take that question on, but I figured I would put it forward.
Well, I'll just say I don't think this particular initiative really connects to that question at all. This particular convention on prevention and punishment of crimes against humanity is quite different from the International Criminal Court. I mean, I think it, in a sense, can complement it for those states that are parties to the ICC statute, but the International Law Commission's approach was to develop a project that states could join whether they were a party to the Rome Statute or not, and was focused on national laws, national jurisdiction, so not really speaking to that. If I can, Melody, I also noted a question about, does this project deal with the issue of aggression?
Yes.
And maybe I'll just note that the ILC, thought about whether the issue should be broader than just crimes against humanity, should be war crimes, should be genocide, should be aggression. We felt that keeping it focused on crimes against humanity was appropriate, that there were other treaties dealing with these other matters, that really you needed to keep this in a certain scope so that it could be, digested by states and move forward. So we didn't take that on. I think there was also a question about cyber activities, and I would just say that the commission thought about cyber and viewed that however you might commit a crime against humanity, whether it's directly engaging in acts of violence or whether it's engaging in some sort of digital tool that gets you to the same place of heinous acts, certainly it could cover that, but we were not trying to pick up things that are already being regulated by, say, the UN Convention on Cybercrime or the Council of Europe's Cybercrime Convention. We thought we would leave that to other matters. Having said all of that, it's up to states now to decide what they want to do with this project. And as you've heard from all those who have spoken, there's lots of ideas for ways to embellish on what the ILC has done. And it's entirely up to states now to decide what they want to do in that regard.
Thank you. Does anyone else have any comments on those two particular points that Sean picked up from the chat? Then I'll move to, there was one also from an advocate in Pakistan, which reads, since we are discussing the Convention on the Crimes Against Humanity, as stated by the ambassador, implementation will not be straightforward and will be complex. The question is whether the committee or ILC is also looking, or the community perhaps is also looking forward to suggest or advise on enhancing or changing the methods of implementation or enforcement for such crimes, since the biggest obstacle that ICL today faces is enforcement, and the principle of complementarity usually gets in the way. So I guess the sort of short question is to think about what are the provisions regarding implementation and enforcement. And I think a couple of you might have touched upon enforcement, but please, whoever would like to pick that up. Sean, you might be the natural sort of first position on that, since you're the rapporteur for the articles themselves.
Well, I'm also the only one here who doesn't have a government behind me, sort of with guidance and instructions. So I'm sure,
Yeah.
everyone wants to be cautious in that regard. I'll just say the entire project really is about implementation and enforcement, right? We've got the concept of crimes against humanity. We've got a possibility of them being prosecuted at certain international courts and tribunals. But the whole idea here is, how can we enforce them? How can we implement the prohibition on them in national legal systems? That's what this is all about. So in essence, we're trying to harness the existing national criminal legal systems to not just prosecute the crimes they're already prosecuting, but to prosecute these particular crimes against humanity. Now, there are other ways one might think about being sure that states do this. And I think Anna Paula touched on this when she said there's a proposal for having a process of sort of ad hoc commissions that might look at particular situations. There's the possibility of a committee that could address this in the same way you have a human rights committee or a committee against torture. There's the possibility of annual or biennial meetings of the state's parties to the convention. Lots of different possibilities for sort of oversight of a sort. Again, this will be up to governments to decide. We have models for this in other conventions. They do require resources. They do require political will. So it becomes a real question of what it is governments want to do. But I certainly imagine that will be a part of the negotiations as they move forward.
Ana Paula?
Thank you. Yes, precisely thinking of challenges in the implementation of the convention, in additional provisions or a new provision, Mexico presented the possibility of having a treaty body focused on capacity building, precisely because this convention also foresees prosecuting in the domestic or national jurisdiction of states. So when we were thinking of the possibility of creating these capacities nationally or domestically, usually we think that our judges might not have all the experience or might not be experts in international criminal law, and it would be important to have this sort of committee making sure also that states have this capacity, but also to ensure coherence or certain uniformity in the implementation. So this idea was also of the treaty body was also taken from actually the first drafting effort of these draft articles, coordinated by Professor Leila Sadat in 2008. I think they started drafting this process. So it was taken from there, but also thinking of or taken as inspiration some relevant human rights treaty bodies and the experience. And we thought, and we might look at other models, but we thought the subcommittee for the prevention of torture has this model of having or keeping confidentiality when visiting states, and focusing on capacity building rather than just monitoring or creating more responsibilities for states to present, periodic reports. So that's why in our proposal we took this model, but we thinking of the process of implementation as a possible challenge in the future.
Thank you, Ana Paula. I know we're sort of almost out of time, but if one of the other, Marang, do you have something to add?
Yes, thank you very much. Again, just with regards to what Anna had said, Gambia also did with Sierra Leone and did propose to have a treaty monitoring body. We should also have the capacity to engage in technical assistance, capacity building, but we also propose that it should also have a monitoring aspect in terms of monitoring what states are doing in the implementation of the treaty. So we didn't just say that it has to focus on capacity building and technical assistance, but our proposal also went further to indicate that it also has to monitor the states in their compliance of the treaty. But we are also looking forward to more, of course, more options if it is available to strengthen that monitoring aspect of the treaty. Thank you.
Thank you. And I do recognize that there was one final question, but I am going to take the, I'll read it, but I'll just take the moderator's prerogative and just say probably I don't think anyone here would feel that they can speak for what the views are of the US, UK, and France, the other permanent members of the Security Council. So unless someone really wants to dive into that and express those views, I think we will go ahead and end it there. But if anyone wants to say if there's an easy way to say that, feel free. In terms of what the views of U.S. Okay, I see that the Jackson Center is going to answer the question, I guess perhaps in a different format. I recognize that we have a couple of other questions. I'll see if there's any way to answer them quickly. Would it include any provisions on reparations or post-conflict reconstruction? I think that was discussed somewhat as aspirational, at least. But certainly the current articles don't include, but obviously it's a negotiation. But I understood, and I see Ana Paula shaking her head, that was referenced as something that could be possible, sort of the importance of truth reconciliation committees, which certainly, and I agree, in Latin America, they've had a lot of experience with that. I think also, frankly, in Africa, there's been some experience with that. I will end it by saying thank you very much to Sean, Ana Paula, Ambassador Melnick, Marang, James, Theo, and I see the double Andre. But thanks so much for sharing with us where this is. Obviously, there's a lot of work ahead, but we really do appreciate it, and appreciate your sharing where everyone is to sort of bring us all up to speed on this. Wishing you much success in your work. As you've all said, it will not be easy, but it is so critically important that really thank you all very much. Thank you also to my colleagues at ASIL and also to the Robert Jackson Center for putting this on. And I think there's a lot of interest. There's also some information for folks who are still on the webinar in the chat box, different pieces of information that you can access. So, and there was a question asked, and yes, this will be posted on ASIL's website. So with that, I will say thank you to all of you for joining us, and bid you all a good afternoon, good evening, good night, depending on where you may be. Take care.